Welcome to Homeowners for Justice. This is CJ Holmes, founder of Homeowners for Justice, bringing you a new show today with two fabulous guests. They're going to discuss and share with us all of their knowledge in the industry about what options owners have when they're facing foreclosure, or even perhaps before they're defaulting on the loan. So many people today are upside down and they're fearful. They don't know what the future holds. And so I'm bringing you today some specialists that can talk about various options and also what owners will face if they have to go to court themselves as pro per. Many people cannot find an attorney to represent them, no matter how hard they try or no matter how much money they have. Attorneys really don't either know what they're doing or want to take on these cases. So today, before we get started on the show, I just wanted to bring a couple of recent headlines to your attention. The state of the country, it is not a good thing, and I've said this before, I want to say it again. The people really don't have any friends. And the facts of the matter are the powers that be are willing to take others, charge judges, charge owners that try to do things to protect their assets, and they will charge them with fraud, but they won't charge the banks at all. The banks get a pass and they get a bailout. So here's the first article. A judge in Detroit is now being charged with fraud. She's evidently trying to hide a house that they owned down in Florida while they were negotiating a short sale. I'm telling you, the banks have taken so many assets from the people. I know that perhaps what she did was not, quote, legal according to the bankers' rules, but the fact is they have been fraudulent foreclosing. So let's start to foreclose and charge people correctly with the fraud they're doing. Here's a nice article from Ellen Brown. She's a real champion of public banking. And she wrote specifically about the $1 trillion coin, joke or game changer. And again, we're back to, we don't have to put up with this. And when we fight back, we have to have solutions. And one of the solutions is changing the money. We've got to understand that the money we use, take one out of your wallet, take it out of your pocket, look at it, read the very top label. And what does it say? Does it say US dollar? It does not. It says Federal Reserve Note. And right now, all the countries basically in the world and most of the states are literally allowing the private bankers to loan us money. The Federal Reserve loans this government, us, money, and we have to pay them back with interest. That's insane, because they will constantly suck all the wealth out of this country. That's the whole point. And the fact is, Congress does have the authority. Right now, they have the authority to create coin. And that's what this is talking about. It's a game changer, because the U.S. government could decide, they could, if the people are back it and want them to, they could change the dollars, they could print, they could decide, we're going to take that power back. We're going to not give it away to the banksters anymore. We're going to keep it for ourselves, and we're going to print actual U.S. dollars, and we will pay the Federal Reserve back. That would eliminate all of the interest payments, which is now 40 or 50% of the federal debt, annual debt. So let's stop giving our lives and wealth and time and money away to the private banksters. All of these articles, by the way, are linked on my page, Stealing Our Homes. It's a log of all of these articles, so you can find them there, and I will also link these on the comment section after the live stream. Just another one I wanted to bring to your attention, these whistleblowers. Remember when we first started this show, the first week of January, actually on Jan 7, I was super outraged, and I still am, but that is the OCC, the Office of the Comptroller of the Currency, has settled with the banks for another $8.5 billion, which, as we know, is pretty much going to come out of your and my pockets and out of the currency. It will not come out of the banksters' private gains. Trust me on that one. But the whistleblowers have revealed that extensive borrower harm, and it was an orchestrated cover-up to keep people in the independent foreclosure review, to keep owners from getting any money. So they would find the people, auditors hired to do this, they would find problems. They would find forged notary signatures, forged signatures, made up titles, agencies and attorneys, in fact, that are made up. That's what's on our recorded documents, guys. We got to get this message out. It is a complete fraudulent machine, forged documents that are taking these homes away from the owners illegally with forged documents. And of course, like I pointed out, if the owner or a judge or somebody does it, some little thing, they're going to get prosecuted to the hilt, and the banks get a walk. And so this article talks specifically about how much harm was done. And then you're going to love this last breaking news just yesterday. Most mortgage-related TARP money remains untouched. So that's still in the Treasury. I'm telling you, Geithner is not our friend. And if you don't believe me, you've got to read these articles. And he and Bernanke, they're controlling everything. Eric Holder, Department of Justice, longtime bank attorney. So listen up. We need to let every one of our friends know. We need to contact everyone in each county, wherever you live, in whichever county, in whichever state, it doesn't matter. All of us are facing this same horrific river of fraud and have to fight back together. So without ado, let's get talking to our first guest today. I've invited Damian M. Holtz, and he's from Real Estate Settlement Resources, a nonprofit that helps owners really figure out, before you get jerked around by a servicer, it's possible to know what your options are. Like, do you qualify for a HAMP or not? Rather than just letting some bankster servicer say yes or no. And I already can tell you, because I've had another attorney, Jeff Burns, that's doing a class action against Wachovia. He was telling me that over half of the loans that should have qualified for HAMP never got approved because the banksters have gotten more money out of the FDIC and the government for foreclosing. So it's our whole government bankster cartel that's fighting against the people. So, Damian, welcome to the show. He's on the phone today. And why don't you tell us a little bit about yourself and your company, and then we'll get into some owner options.
Absolutely. Thank you for having me, CJ. Well, I'm here representing today Real Estate Settlement Resources. We're a 501c3 nonprofit organization. As well, I am a licensed private investigator, specifically working in the mortgage fraud investigations. But what we're going to talk about today is the nonprofit and really understanding what some of the solutions are available to you. Okay.
Thank you.
CJ kind of mentioned that servicers are making exorbitant fees by foreclosing on homeowners, as well as a lot of the law offices out there are charging exorbitant retainer fees, and or they're charging low fees and nothing's getting done. So most importantly, what we want to be able to provide a homeowner is their full understanding of what their current financial situation is versus what the value of the property of today is, the fair market value. And the reason why this is important is because this is how your servicer and the investors on your obligation are assessing you. Okay.
Theoretically, right? This is how they're supposed to be assessing us.
You're exactly right.
Okay.
Absolutely.
All right. And here's one of the problems that we all face, and that is, are these guys telling us the truth or not? And we already know that by lying, they win. So we feel like we have no clout. Go ahead, Damian.
Oh, no, absolutely. And so some of these key phrases that we're going to use today, like net present value or an AVM, understanding whether or not, let me go over those two things because I think it's very important for a homeowner to understand. What net present value, what the servicer is assessing that is what your current financial situation is versus the net present value of the property today, or fair market value. That's how they're looking at the cost-benefit analysis of how potentially putting you through a government-sponsored program, such as HAMP or HAMP Up, and those different options, or doing an internal restructure of the obligation itself, and that cost-benefit analysis between foreclosing and actually restructuring for you. Okay.
And Damian,
and this is information that can be done in a short amount of time frame. We can go over your current situation, go over all of your obligations not you actually qualify for a HAMP modification or not. That's really your decision, but that's information that you need to be armed with as you're dealing with this servicer. She did a great job kind of expressing of what some of the scenarios are out there. You guys have all heard their horror stories of, I'm underwater and I make too much money, they won't help me. Well, that doesn't mean that you don't qualify. That's just what the servicer's telling you.
Exactly. See, and Damien, this is one of the problems when the people, because literally it's divide and conquer. These banksters have figured out that if they keep all the homeowners isolated, and every homeowner tends to start buying into I'm a deadbeat or they won't help me, and they don't know where to turn, they don't know who to trust. If they hire some attorney, they often lose their money, they get nothing out of it. It's really a crime. That's a secondary crime, insult to injury on top of it. And so there's no way that I've known in advance until I've met you just recently and about your services that a person, an owner, could actually evidently contract with you for some fee to find out what their situation really should be according to the, quote, current rules.
That's exactly right, yes, ma'am. And part of the other side of the equation that homeowners face a challenge every day is actually dealing with attorneys as well. And,
Yes.
to put it in perspective of that business model, these attorneys have marketing fees. They have hard costs for the folks that are actually doing this work inside there. You're walking in and paying a retainer before anything is ever done or figured out on your property. And
Right.
you're put into a situation to where you're kind of being led without really understanding the dynamics of what options are available to you. By working with a nonprofit organization, their criteria of what they have to meet as far as dealing with the homeowner is making sure that the homeowner is given all of the options that are available to them. Also, not only just be giving that information, but going through their specific financial situation and how that affects the different options that are available to you. You may qualify for a modification. You may not qualify for a modification due to income. You may not qualify for either one of those scenarios, and maybe a deed in lieu or a short sale may be the best option for you. But there are requirements for those scenarios as well, which a nonprofit organization such as ours can go through all of that information, provide you with a tangible work product so that you understand, I do qualify for the HAMP program. I am net present value positive. A short sale isn't in my best interest, or a deed in lieu isn't what I'm looking for. Maybe you're looking for litigation. It just depends on what your specific scenario is, what the disposition of the property is, and how we guide you to help you make that decision for yourself. Not only what's best for you, but that you fully understand the decisions that you're making without financially committing yourself to a big retainer fee, without putting yourself through the ringer with dealing with these servicers. We want to make sure that you financially understand all of your options, what's available to you, that way that you can make a decision on how to deal with your servicer and deal with your bank.
Now, Damien, isn't that sort of the summary of what you've termed the LDA report, which is a loan disposition analysis? I have to write it down so I remember.
That's exactly right. That's exactly right. We've, under the requirements of the nonprofit, what we've done is looked at all of the different options that are available to you and put them in a cogent format within the LDA so that when we do your current financial workup, we take those factors, and that'll give you a pass-fail, let's say, for instance, on the HAMP program or any other government-sponsored programs. You're going to see a pass-fail on those different scenarios so that you actually know what you qualify for. And if you don't, we'll give you the reasons why. If you do, we'll also give you the reasons why.
Okay, so Damien, so if someone wants, when you start to do this analysis for a person, an owner, what kind of information do you require? Is it the same kind of information that the servicers typically ask for in either a loan mod or a short sale?
It is, yes, ma'am, absolutely. We're going to do, just like when you originally took the loan out, we're going to do a full financial workup on what your debt-to-income ratios are, what your current revolving credit lines are, et cetera, et cetera. So we do a full assessment on what your total scope of your financial picture is. So yeah, it's not ominous. It's it's a few pages of information to say, for instance, if a short sale is in your best interest, these are documents that you're going to need to submit while going through that process. So it allows us to collect all that data, put it in a format so that you understand your options. In addition, if you need help or you make a choice, you'll have all of that stuff put together for short sale, deed in lieu, litigation, whatever your choice is.
And Damien, I just had a thought that made me grin, and that is, how many times do you guys lose the paperwork?
How many times do you lose the paperwork? Impossible for our we've built a customer relationship management to deal on the day-to-day side of working with a homeowner so that the homeowner has contact on a daily basis as far as dealing with us on what options they move forward. So, for instance, let's just say, for instance, if a homeowner wanted to move forward with a modification, they've shown that they're HAMP positive and they move forward. The homeowner can log right into the CRM, upload their documents, and that file is off and running onto production. If production side is pinned to file for financials or additional documentation, they'll pin that file, and the homeowner will automatically receive an email letting you know what additional documentation will be needed. The homeowner logs in, puts in their documentation, and moves on. So we definitely have made sure that from a customer service standpoint, that's the most important thing.
Right, and you know where my question came from, right? Not from the fact that maybe you lose paperwork, but the fact is that the servicers and the banksters have made that a strategic plan. They intentionally tell you they've lost the paperwork.
Yeah, if you've ever looked at a servicer participation agreement, that's what the servicer signs into when they're dealing with the master servicers of these trusts to service these loans. And there are exorbitant fees that these servicers make in foreclosing on properties, on late fees, on forbearance deficiencies. I mean, you've heard every trick in the book. These servicers are, what's the best way to describe it? Predatory in nature as far as dealing with the homeowner, and that's for their own financial gain.
Absolutely, and of course it's sort of like William K. Black talked about. The fact is, once you start the fraud river, it floats. And so they had the toxic fraudulent loans, so that floats into the predatory servicing, floating into the predatory and fraudulent foreclosures. And it's a free floating fraud now going into derivatives. They literally do everything they can to maximize profits. There is nothing left about fair business practice, legality, working with an owner, nothing like that even gets close to being counted into the formula.
Well, I'm glad that you said that, because an additional benefit and something that homeowners do need to understand is that these servicers do have statutory requirements. Unless you're aware of what these requirements are, the servicer will just continue to act in that behavior. One of the benefits of an LDA or a loan disposition analysis is that you're putting the servicer on notice that you are aware of what your rights are, you're aware of what you qualify for, and any impropriety at that point has statutory liability associated with it, and these are additional things that you can leverage to get to a solution for you.
Now when you say you, are you talking about that the owner can leverage, or you leverage on behalf of the owner, or how does that work?
You know what, for this particular product, this is a scenario that the homeowner can take that, and if they choose that they want to deal with their servicer and negotiating with them, that is a great tool to do that. So whether you work with a nonprofit or not, that's a work product that you can take away and deal with your servicer on your own terms.
And so the LDA report actually, that's the loan disposition analysis. I like to keep reminding people what these acronyms stand for because it's easy to forget. And so that report that I just had up on the screen, it's several pages, and that actually includes the statutory requirements that you just mentioned?
No, we don't. In this particular loan disposition analysis, and what I did is I just sent the content for everybody to go through to fully understand, kind of sink their teeth into what is available with that.
Okay.
We don't make any legal advice or anything as far as on the LDA report, but no, there are statutory requirements, and we will make those available to anybody that works with us. Absolutely.
That's great. And see, I just want to remind people that many states, including California, have now enacted tougher foreclosure laws because of all of the fraud and abuse. And, people are arguing, did it go far enough? It didn't go far enough, but it's something. And it's better than what we had last year, which was a whole lot less. And so in many states, you need to check into what foreclosure laws are available. What are the statutes? We're working on trying to help people get that information so that they can actually quote those statutes and laws. The trouble is, what we find often is that no matter, it feels, the owners are saying, we send all this stuff out and then they foreclose and they take the house. It doesn't stop the auction. So does anything like this LDA report or any of that kind of stuff help owners stop foreclosure auctions?
Yes, and we'll use a specific format. If there is a HAMP application that has been filed, then it will potentially stop the trustee sale. That's typical. That's the other benefit of knowing that you qualify for it, so that when you're dealing with your servicer, if it comes down to the wire, you're able to present that information and more likely for them to work with you. But I don't want to misrepresent the work product and say that it's
right.
going to stop your trustee sale, because I wouldn't do that. But it definitely will give the information that you need in working on getting the right packages in, which will stop the trustee sale.
Can you explain once again, please, what that NPV and its net present value actually, how that's sort of, simply calculated? Because I've seen.
Let's put it in layman's terms on that side. So we don't keep using acronyms. What the servicers and the banks are protecting, I guess, at the very essence of all of this, is their REO inventory. Okay, that fair market value number is a very, very big number as it pertains to the inventory. So they're protecting that at all costs. When you originally took out your loan, and folks have taken out all different types of loan programs that were available to them during those time frames, but let's just say for a conforming loan, you had to provide income information, you had to provide all of your credit lines associated with that, so that you could factor what your debt-to-income ratio is. So what you guys need to understand is that this is the way that the servicers and investors are looking at you again. So that net present value, that net present positive number, is a very, very important thing for you to understand. That means that NPV, what that is, let's get into detail, that's your current debt-to-income ratio versus what the fair market value of the property is. And what that means is, let's put it in an analogy. If you were to go to an attorney and say, I want to litigate and I'm looking for a principal reduction, and the attorney is just as happy as can be to take your money and move forward.
Right.
Well, what's important is that you need to understand, and the lawyer needs to understand, and the servicer needs to understand that if a principal reduction was to take place, would you even be able to afford that today?
Right.
And that's why that number is so important. If they were to give you a principal reduction, would your current financial situation be able to support that new obligation? This is how the banks are making their decision on restructuring these assets for you. So that NPV positive is the most important thing, for sure.
Now, Damien, you said something that really caught my ear early on, and it was in this last discussion. And it was that the banks, servicers are trying to protect or protecting their REO inventory. REO is the foreclosures. It stands for real estate owned. And these are the properties that they currently own but have not sold. They've not listed them and sold them, or sold them to a hedge fund in bulk, or they still have them under their assets under management. Now, does this, what I'm thinking I hear you say is that if they give a person a principal reduction on a comparable home that they have in their portfolio, does that actually affect the value of that home in the portfolio too? Do you know?
No, because the baseline of the MPV or the REO's valuation is fair market value. So fair market value is going to be dictated by new home purchases, refis, etc. So that's the baseline that they're using for evaluating the new homeowner or their REO inventory, fair market value.
And so even all the REOs they've got go up, or the value goes up or down based on fair market value at that given point in time?
Yes, ma'am, that's correct.
Okay. And so I have seen I've seen people are now sending me their documents and saying, okay, I got a HAMP loan modification. What do you think? And so they fax me that agreement, and some of them actually have split the principal. They first almost always add on they increase the principal with all the back fees and stuff like that. And then they chop that principal sometimes in half, and they call it a performing principal. In other words, the person pays interest on, a piece of that principal, but in the end they have this big balloon. Others are getting complete principal reduction or getting significant reduction and don't have a balloon principal payment down the road. And many people have contacted me saying, I got a loan mod 3 years ago and I can't afford it now. So what do you have to say about those kinds of comments and HAMP, quote, HAMP loan mods?
You know what, that you bring up a great point there. And again, the LDA is going to assess your current financial situation based on what the HAMP criteria is. The results of that modification may be, extended terms, lower interest rate, but the overall end result is that you end up paying your house 3 times all over again. What you're seeing in the industry as far as modifications that are getting principal reductions is a lot of times the homeowner has taken a next step and actually done some discovery on what the disposition of their chain of title is and whether or not the servicer has standing to bring these actions forward or foreclosure actions forward. So when a homeowner is armed with their current financial situation, understanding what that is, also knowing full discovery on all the statutory issues that have occurred during this securitization process, for instance, via chain of title issues, state recordation and assignment issues, UCC issues, so on and so forth. When you have a discovery package that has that data, it does allow you to obviously have much more leverage in negotiating with your servicer or investor.
Okay, so Damien, what I actually heard you say, and I like to put things into, net it out. What you said was, from yesterday, one of your cohorts over there, Joe, was explaining about securitization and how basically Fannie Mae is never even on title, does not have the right. We discussed that, and people listening today, if you haven't watched yesterday, go watch it. Go to my securitization webpage. I've listed all the live streams, all the charts, some basic overview about the tangible, intangible property. So what I heard you say was that as the owner gets these details, if you will, in an understandable format, like with a chart, and also perhaps even notary complaints because of forged notary signatures on their documents, things like that. Those facts can be used to help in the negotiation of a loan mod.
Yes, ma'am. And I want to make sure that the listeners understand that there are 2 fights here on this front. You have your security instrument or your deed of trust, which is the collateral for the original obligation, the note that you signed. Okay, then you have the obligation itself, which has been sold on the secondary market through securitization. So what you're doing in litigation or leveraging the improprieties or statutory federal issues that are associated with securitization and the improper foreclosure on the asset, you have a lot of data based on protecting the property, but now the servicer or the investor has to take that into assessment on the overall bottom line of structuring this deal with you. So if you have the tools in order to litigate and show that your servicer doesn't actually have beneficial interest in your note, in your original obligation, and is not a decision maker, they have to take all of that cost associated with litigation, etc., potentially losing the property, which allows you to leverage that to get to a much better scenario as far as a principal reduction through a modification.
And still be able to keep the property with something that you can afford.
Yes, ma'am.
Yes.
That's correct.
Yes. This is really fabulous. And the next guest is on the line, but just before we go, he's going to be sharing with us about doing pro per. That means representing yourself in court, because so many people either can't find an attorney that knows what they're talking about, finds an attorney, just like Damien has said repeatedly, they'll take your money. They have no problem with that, but they won't necessarily even know if you qualify for whatever you're trying to obtain, which, up until now, the biggest question is, how do I find a good attorney? And of course, it's the wrong question. What we need to know is, how do I get all the facts? Because if you have all the facts, then you could probably take it to most attorneys and they could represent you well. That's what I'm thinking. It's mostly the attorneys do not understand real estate. Most attorneys really don't. I've heard that from other attorneys that are into real estate law, and therefore most judges that come from attorneys don't understand real estate law. So there's a lot of non-understanding going on in the court system. I've had it said to me repeatedly, the owners would win if they knew how to file the right pleadings.
Exactly right.
Yeah.
About the application. 100%.
And so I've been out here asking everybody, okay, what are the right ones? Come on, tell us, because the people want to keep the homes. They just want to keep their homes, and they are so chewed up and spit out and have lost trillions of dollars. I mean, we've got William K. Black already telling us it's an $11 trillion hit on the people and 7 million jobs lost. And yet the banks, now have trillions in derivatives and are making all kinds of money. I mean, that's the second step, because the first step we need to do, let's never forget, we got to keep the houses. Don't ever forget, I put it on my slide here, J.P. Morgan 100 years ago said, foreclose as fast as possible because people without homes, in other words, renters, tenants, are much easier controlled and less likely to fight with their overseers, their supervisors, their officials. And that is really what Damien and his crew is on board to help us do. We thank you so much for sharing, and we look forward to having you on again. And if anyone watching has questions, just contact me and I will put Damien in touch with you.
Thank you so much. Thanks for having me.
Thank you.
Okay, bye-bye.
Bye now. All right, we've heard from Damien and about options that owners have, and the fact is the more we know about what our options are, the better we have of getting a better loan modification. We can use these facts to negotiate from a stronger position. Now, like I've said repeatedly, many people cannot find an attorney that will help them. And so a lot of owners ask me for pro-per help. Where can they go? Where can they get questions answered? And I've got Harold Ellis Beal on the phone with us today. Thank you, Harold, for joining us.
Thank you, CJ, for inviting me.
Can you just tell us a little bit about yourself, about the Non-Guru Network and what PMA stands for, and what you offer, how this works, what the pros and cons are of representing yourself, that kind of thing. We'd appreciate your sharing.
Okay. First of all, the Non-Guru Network was something that came out of a need to help people who take on the journey of representing themselves. However, I've been involved with a lot of groups, spoke on a lot of shows, oftentimes working in a support role. And there were two gentlemen in particular, one on the East Coast and one on the West, that had advocated me starting my own group that people need to hear me. I resisted it for about a year. And then the one group that I was in, some unsavory things that happened and pretty much propelled me to go forward with the suggestion. And hence, non-guru, meaning there's no guru, no boss, no ego-inflated head at the top, dictating things down to the membership. I kind of resent that because I found that happening time and time again. And a lot of things don't get done when there's a lot of the groups around the country that, purport to help people, but wind up, resorting to infighting. Groups don't work with other groups, et cetera, et cetera. So I wanted to put something together where, there is no top person per se. Groups work with other groups, as we do. Getting to the PMA, because I know we have limited time here, so please forgive me if I'm not exhaustive in what I'm
No, that's fine. That's fine. You've got several minutes, and we can run over a little if we have to. So don't worry about it. Just we really want to know what people can get from your group and how it works.
Okay, now the PMA stands for Private Membership Association. What that entails, a lot of the groups operate publicly, and what happens is if they get too close to the prize, the powers that be, oftentimes resort to unjust prosecutions, etc., based on things people are advocating, saying, or that is against the establishment. With a private membership association, which is protected by the First and 14th Amendments, like-minded individuals can come together in private in which the public authority has no jurisdiction. Give you case in point, some of the groups that actually control a lot of things that go on in the world, and if they're based here in the United States, often use this status. Take like your secretive trilateral commission, the Bilderberg groups, and things of that nature, which people have been crying out for ages for the government to do something about these people who are instituting policies that affect the world at large. However, because of their private membership association status, the public authorities are without recourse to enforce unless they can prove that their policies or what have you are actually affecting the public. So therefore, you can't go into a private association membership and then advocate, murder or anything like that. Yes, they can come in on that. But as long as you're legal, they have no recourse to attack you. And I chose that realm because of what I've seen going on around me. Now, a little bit about myself. I've been involved with the law for about 30 years now, for about 26 years, and then basically out of a hobby. For about 26 years, I did it, absolutely free. After I got out of the real estate business, I started personally, charging for my services. However, once I learned what was going on in the banking institution, I had a dilemma. Either I would become part of the solution or part of the problem. And I chose to become part of the solution, which cost me quite a bit of money, but I do not regret the decision one iota. And I've been on this journey since about, I would say, 2007 or 8, in this realm with real estate, foreclosures, and credit card issues. I've been also involved with criminal law, matrimony, and other civil matters. So what I've discovered is that I've learned when I got into the foreclosure aspect, I literally almost took about almost 2 years of intense research and investigation to the exclusion of personal activities, etc., to bring myself up to speed of what was going on in this arena. And you see a lot of methodologies and approaches to the problem. Some of them are, way out there. Some of them have merit, but are not acceptable in the courts. And I played with, some on the left and the right, with limited success. So it came down to the point that I said that, wait a minute, we have to stay in a realm in which the courts will hear your pleading.
Right.
Based on authority that it accepts. When you're in Rome, you do as the Romans do.
Right. We have to fight back on the legal groundwork that we already have and to get the courts to listen to us.
Right. And what I've discovered, because, my father, who's very instrumental in my life, used to always say that, when you get involved with something, you try to make it better and more effective using less energy. And using that approach and methodology, and I've done it, pretty much all my life, and I discovered that I think we'd have made the situation more complicated than what it actually is.
And you're referring now to fighting back against foreclosure?
Fighting back.
Okay.
We have various elements in our favor when you go into court, whether as a defendant or as a plaintiff. Number one being that the majority of the entities that are coming against the homeowners are oftentimes third parties.
Can you speak up just a little bit, please?
Yes, I said majority of the entities that are coming against the homeowners are third parties. They're not the original, so-called original lenders.
Right. They're attorneys for
with
the...
regards to evidence and the rules of evidence, which is crucial in this whole thing. As an associate that many of the listeners may be aware of, Dr. Graves, who produces the jurisdictionary program, which if any homeowner is even considering representing themselves, must have that program. And he often states in his literature that evidence is the key to the whole process. And when we say evidence, we're talking about admissible evidence. And the majority of the evidence that the banksters use with their servicers and their lawyers oftentimes is not admissible. So therefore, the key is to get as much evidence in your behalf on the record and keep out any evidence that is inadmissible. And it's not that difficult. Now, one of the keys to keep a lot of it out of the record, and it's almost in every case that I've come across, attorneys are oftentimes offering up evidence without a foundational witness. Well, what is a foundational witness? A foundational witness is someone who has personal knowledge that can authenticate a document or an event and to adduce it into the record. Attorneys, by and large, cannot do this by rule, by their own bar association ethics, and by Supreme Court precedent. So therefore, an attorney cannot represent and testify at the same time, and he or she cannot testify to things that they have no knowledge of. And so in most of these third-party cases, you have attorneys testifying or offering up evidence, oftentimes unobjected to, whether it's by a pro per or an attorney representing a homeowner.
Exactly.
And therefore allowing this evidence to go into the record, evidence that is not admissible. So if one was to employ just the rules of evidence, and by the way, people in my program often hear me reiterate over and over and over again, because I'm a firm believer in the psychology of repetition. There are many, many groups out there that do fine jobs and helping people with their facts, helping them find the law, and creating arguments.
Right.
What happens most of the time is the people get killed by not knowing the rules, not knowing procedure.
Right.
And so, therefore, when you go into court, and this includes attorneys, because believe it or not, I actually train attorneys also in this foreclosure arena, because most of them have no clue. So what Damien had stated and what you had stated with regards to lawyers not knowing much about what's going on,
right,
that is so true. By and large, most of them know nothing, because they're actually even trained in the schools. This is why Jerry Spence out of Wyoming.
Keep speaking up, please.
Why Jerry Spence out of Wyoming had created his own law school, because he was sick and tired of attorneys coming out of school knowing nothing about the law. They're taught primarily about procedure, right, and also about negotiating.
Right.
Many of them don't know much about law and argument. That's why when you go into court and a pro per comes up with a little knowledge and goes against the attorney, oftentimes they spank their butts.
Right.
But the attorneys don't know.
Right.
Bad, because they come off as if they do and take people's money, and they're just robbing them and doing nothing for it.
Yeah, paper tigers.
Yes. So the key, because like I said, there's a lot out there that they can get right off the internet or get involved with some of the groups in their area or some of the groups that are nationally syndicated. syndicated. They can help them with the law and the facts and how to formulate arguments. That's not a problem. What we do is focus also on procedure. And like, take for instance, our platform is a little different in this regard also. A lot of platforms, they'll have callers call in with their problems. They may be able to ask one or two questions and they go on to the next subject.
Right.
We don't do that. What we do, we may take one or two cases and do a thorough examination from a global perspective of the issue. And being that a lot of the issues are similar, you're
Absolutely.
going to get something that will be pertaining to your case.
Right.
And we have found that over the last couple of years that people indeed have gotten a lot more. Like, we just had a lady from Colorado just came to the group, and she stated in the email to me, she said, out of this one call, I've gotten more than all the time she's been involved in this.
Yes.
Because sometimes you just can't get a grip on things by an answer to one or two questions.
Right. And so often I'm sure that I'm just imagining myself trying to do this. I wouldn't even know what questions to ask. So I'd probably ask the wrong ones and not the ones that I should be asking. That's why going through the whole case makes such good sense.
Yes. And so, we'll take one or two cases and really examine it, and then we invite everybody else to come in and have their input, because we have a lot of other service providers and professionals that are involved in the group that offer up their insights. We also have an alternative health component, and we have a lot of professionals that are part of that also. But it's so much I can say, but I know our time is limited. But
Well,
the key, I say, for people to do is, number one, educate themselves of the process.
right. Now, you sent me an application. If people wanted to join, can I upload that application on my website? They just go there and fill it out, send it in?
Yes, you can.
Okay. And then I'd like you to emphasize again the rules of evidence. Say that. And is there an article, or how do people find out and learn about these rules that you were talking about? Do they have to join the
Number
group,
one,
or what?
each state has one, and there's also a federal. Under the United States Code, you have the rules of evidence, and each state has their own. And most of them are online, but what I often recommend is that people, two investments you want to make in this process. Actually, three.
Speak up, please.
Jurisdictionary, number one, you must have. Number two, rules of evidence for your state. I recommend that you get what they call the annotated version of it. The annotated versions includes the rules, commentary, then case law and support for every rule in the book.
Right, so that when you go into court, either your attorney or yourself, you can quote the case law, right?
Well, yeah, most of the time you want to have all your case law quoted in your paperwork.
Right.
Your paperwork should precede you going into court. And so your argument should be settled on paper before you go to court. Basically, the court proceeding is to go over the pros and cons for the court to make a final determination of what's going on. But your 80% of your case should be on paper going out. Matter of fact, for people that are not familiar with the process, I often encourage them to, get very good in getting it on paper and having people to help you do that. And if you cannot answer the questions accurately, but they're in your paperwork, you stand on your papers, because you got to be very, very, very careful what you do, say, and allow in a court setting.
Right.
Because what happens is, take for instance, you have something on paper saying 1 + 1 is 2. Okay, and you get into court, and through technology or what have you, they get you to say that 1 + 1 is 3. Well, the court will go by the last thing stated or entered into the record. So if you come out of your mouth contradicting what you have on paper, they will go by what you say out of your mouth. and you basically canceled out what you said on paper. That's why you have to be very careful, because they are masters at getting you to sink your own boat.
Right, right.
They are masters at that. And this is why I'm in an agreement with people like Robert James, who I think should be a guest on your show. He offers a very nice book, Fighting the Foreclosure Machine. And one of the things, and he's a former attorney who's helping homeowners. We should definitely get together.
Yes.
He often states that the homeowner should never, ever, and I was so glad to hear this because I've been a proponent of this for years, never, ever admit the debt.
Right.
Never, ever admit the debt. As soon as you admit the debt, it is over.
Right.
Literally, it is over. They don't want to hear nothing else, or they may allow you for appearance sake to go on, but once you made that admission to the debt, it's over.
Right.
And
right.
because we know those that have been involved with this for a while, they cannot validate the debt.
Exactly. Exactly. So don't admit it. If you admit it, then you owe it.
That's it. And they're going to go by your word. You said it.
That's right. You said it, so we gotcha. That's fascinating. Now,
the biggest thing they use against the homeowners.
You've evidently you have some kind of conference calls or weekly calls. How does that work when you're discussing these cases?
We get together on Wednesday evenings, starting at 9 o'clock Eastern Standard Time. Actually, it's only supposed to be 2 hours, but rarely ever it is. Normally, we're not done until like 1 or 2 in the morning.
Oh, wow.
Because once I get on a roll, we really go.
Yeah.
And so that's when people are invited to come share or come to learn. And we go over these, like I said, we go over the cases exhaustively. We don't just do 1 or 2 questions and move on.
Now, is there a fee to join this conversation? How does that work?
At the present moment, there's no fee to enter it into the group, but there will be in the immediate future once we get everything set up with the website and things of that nature. But it will be nominal because everything we do, we try to have the homeowner's interest at heart with regards to making things as feasible as possible and inexpensive as possible.
But they would need to fill out that application.
We offer an audit service in which I was able to negotiate a great price for the group, which is below market value. These are the types of things we do where we try to make it easier for the homeowner.
Right. And they would still have to fill out that application to basically be invited, correct?
Yes.
Because it's a private membership association.
Normally do invitations through, word of mouth, like take for instance, you found out and you inviting your people to come in, and then they fill out the application because to keep the PMA status,
right?
Private membership association, it can't be easily accessible, and it normally has to be done by some application of some sort.
Right.
So, this is why you have to do it this way to keep that status.
Excellent. Okay, and Harold sent that to me, so I've got that, and I will upload it onto the website. I think I'm going to just put it in my foreclosure defense page because that's where everyone goes. They go to the foreclosure defense and filing complaints because we have found, from what we've been told by insiders in the banking industry, that filing an OCC complaint can help postpone auctions, and most of the time it does seem to be helping and working. So I'm constantly... If
nothing else, it gives the homeowner an opportunity to get a game plan together.
Yes.
And because I found that the OCC does slow things down, but it doesn't correct many of the problems we see.
Oh, absolutely.
However, it does provide the homeowner some time to get a better plan in place to attack the banksters, because the bottom line is there's a great shift of wealth and property from the have-nots to the haves.
Exactly.
By means of nothing.
Exactly.
Giving people something with nothing.
I know. It's fiat credit, and they're taking our real assets. It's an outrage, and we have to get more and more owners either and not just those facing foreclosure. People need to understand this is a threat to the entire country, because as a homeowner who's not facing foreclosure, didn't lose their job, can still make their loan payments, but they need to understand that what is being allowed right now is that the banks are using fraud to steal real estate. And unless we stop
outright fraud. Matter of fact, if you and I do what they did, they will put up.
I know. This is I know, and I know I'm preaching to the choir, but this is why the choir, come on guys, we're singing, we've got to get this out to the public. This has to hit mainstream media. Everybody, all those news anchors, everybody, all the attorneys, they need to understand that they are at risk too, because everybody in this country is at risk when we allow the financial industry to completely manipulate the government and our laws with fraud.
Well, I ask people, I'm a history buff, and I just ask people to look at what happened less than 2 generations ago in Nazi Germany. Look what happened there and how they took over, and look what's going on now. There's not too much difference. So we can actually learn from history so that we don't repeat it, but it doesn't look like we are. And like you said, the people that are in positions to do something, the lawyers, the policymakers, etc., and they're sitting on the sideline, and what they're going to find out that when it's all said and done, it's going to apply to them too.
Exactly. They've been bought off, and I'm telling you, they've been bought off, in my words, so inexpensively, because when you look at campaign funds, which is typically how the banks are buying them off, funding their campaigns for elected office, they really, I think the maximum was Obama and McCain at the $1.72 million. Others are at, $25,000. They're making trillions of dollars off of this. And so to basically sell out for so little is such a disappointment and an outrage. We've basically got to change the game. We have to change the game because the banks have already won. They've won this monopoly game. And both Harold and Damien are bringing...
Some of the ways that you can do it is not that difficult once you understand the rules. And there's one other thing I like to add before we close.
Yes.
And it's a very important one because you can actually win your case before getting to court.
Oh, I like that one. Tell us how to do that.
Yes, and this is often by... and when I use the term administrative, I don't want to go to the left or the right with regards to those proponents that were using things that were actually illegal. But there's an administrative process that you can use that is legal, that's based on authority that is recognized by the court. And you go to your adversary with notices and demands that are directly, and this is very important, that is directly tied to the deed of trust or mortgage and a note. And if your process is surrounded by that, they are obligated under law to respond if they say that they have a nexus to you and them. And if they fail to respond accordingly, according to the statute, regulations, and codes, then they fall into default. So now when you do go to court, you can present to the court that this issue has already been settled. And essentially all you're asking the court is to validate process and that they indeed are in default, and the matter is essentially closed. All you need the court then is to rubber stamp the matter, and because the court will not get involved with the facts or the merits because that's already been decided.
Have you had people do this?
Yes.
Oh my goodness. And that way the judge, it's out of his, basically out of his decisions,
exactly.
Out of his hands.
The thing that they want to see is an adequate notice. Without notice, there is no due process.
Okay, so what is adequate notice?
Well, actual constructive notice is when you present your presentment, your adversary, get it, and there's proof of it. Proof of service is very important.
Right.
And then the presentment itself presents your notice of claim, fact, or what have you, whatever you're presenting to them, and whatever you request of them to do back that's directly related. This is very important because a lot of people get off course.
Right.
They get into extraneous matters that have nothing to do with the note and the mortgage.
Right.
They focus on the note and mortgage because, keep in mind, those two documents are the law of your case. It actually supersedes statute, codes, and even the Constitution. You may have heard the term, contract is king. So therefore, and a lot of people don't take note of this, including the courts.
Right.
For the courts can only do what you direct them to do. So when you bring forth the controlling document for foreclosure, which is the deed of trust or mortgage,
right,
and they fail to perform the conditions proceedings therein, then they have no right to foreclose. And being that foreclosure is an equity matter, and if you do not do equity, you're not entitled to equity. And if you come forth with unclean hands, you're not entitled to anything. The court will leave you where you're at, and you do not get a chance at the second bite of the apple. So, yes, there's a lot of things you will have to, shore yourself up on with knowledge, but it can be done. I've worked with some people that came on board, and, in less than 2 years, they're dynamos, and they're now helping other people. So it can be done. It's not that difficult. I'm nobody bright. I'm not, extraordinary or anything. I just applied myself, and I say if you apply yourself, you can do it.
Oh, Harold, this is really great news, and we're going to have to call it a day, but definitely, I want to know more about this, and so does everybody else in this country, because everyone is looking for a way to keep their home they just want to keep their home, and they want a loan mod that they can afford. And we really look forward to finding out more about that. We thank you so much for sharing today. And I will have Harold's application and information up on my website after the show. Thank you so much. This is CJ Holmes, founder of Homeowners for Justice, signing off for today. And don't forget, tomorrow we're going to be talking with Renee about how to get recorded docs off of our properties. I'm really hoping we've got something solid there to share. And I also, yesterday, was talking to someone about notary complaints and how strong and powerful those can be. So don't forget Update Fridays. If you have an update anywhere in the world, please call in, tell us about the update, because inquiring minds want to know. Signing out for today. Thank you so much for joining. Talk to you tomorrow.